Good afternoon. Because of some voice issues, this afternoon I am using speech-assistive technology. Today, we are privileged to have as our sister, 5th anniversary distinguished scholar, someone who is one of the world's most renowned thinkers and teachers generally in the field of alternative dispute resolution, also known as ADR, and, specifically, on the subject of legal negotiations. Some of you may have been treated to his student negotiations workshop earlier today. He has made presentations on ADR procedures and effective legal negotiation to over 85,000 individuals throughout the United States and in Canada, Mexico, Puerto Rico, Austria, England, Turkey, and the People's Republic of China. He has made presentations on ADR procedures and effective legal negotiation to over 85,000 individuals throughout the United States and in Canada, Mexico, Puerto Rico, Austria, England, Turkey, and the People's Republic of China. He has authored 5 books on negotiation and ADR, 8 books on the American labor movement and labor and employment law, including employment discrimination, collective bargaining, and arbitration, human resources, and public sector collective bargaining, currently taking center stage with states like Wisconsin and Ohio moving to drastically curtail, if not eliminate, collective bargaining in the public sector. Add to these substantial works close to 100 law review articles and numerous presentations on dispute resolution and labor and employment law, and you can fully appreciate his influence on these fields. His teaching awards from the Illinois, Florida, and George Washington law schools are evidence of what we can expect this afternoon. So it is with great pleasure that I introduce to you Professor Charles Craver, the Freda H. Alverson Professor of Law at George Washington University Law School, who will speak to us on the topic, What Makes a Great Legal Negotiator?
Thank you all very much, and I thank Calvin for an unbelievable introduction. The late Lyndon Johnson, after an introduction like that, used to say he wished his parents had been there because his mother would have believed it and his father would have enjoyed it. What we're going to talk about today are negotiating skills. Lawyers negotiate constantly, even when they don't appreciate the fact they're negotiating. They negotiate within their own law firms. They negotiate with their prospective clients, their current clients, and of course on behalf of those clients with outside parties. Most lawyers have never had any training in negotiation. It is amazing. For years, law schools didn't offer these courses. When I first went into teaching years ago, I was already teaching a course in negotiations as an adjunct at Berkeley. I was practicing in San Francisco, and I was negotiating with my first dean, and I suggested a course on negotiating. He quickly said there is no place for a course like that in a law school curriculum, and I moved on 2 years later to another law school and went back to teaching it. Most law schools hate to teach skills courses. Now they've become more popular because the ABA has put more pressure, and we are doing more of it, and we now have a requirement, and the ABA has imposed it. All upper class students have to take a skills course. For years, I've been trying to figure out what it is that makes somebody a good negotiator. I teach a course, a full semester course, where they do a series of exercises. We study various aspects. We'll talk a little bit about using, in the old days I used Jim White's book and Harry Edwards' book, and then now I have my own books. But what's interesting is they do a whole series of exercises almost every week, and the first 5 or 6 are for practice, and then they do 5 or 6 that affect their grade. I rank order the results from high to low. The exercises tell them exactly how much each issue is worth, tells them exactly how they will be evaluated if they reach an agreement, exactly what happens if they don't reach an agreement, and they take the exercises very, very seriously. They can't take the course pass-fail, and the students who take the course pass-fail do substantially less well on the exercises. So it's the grade that makes them work. I mean, there's just no question about it. If there's no grade, they don't work. I teach a 1 credit hour course that's an intensive course at the George Washington University, and I also teach the Peter Bronstein Negotiating Institute. He's here at the University of Virginia. And there I have 120 students. It's also a 1 credit hour course, and I can't grade it, so it's all pass-fail. They all blow off the exercises. I mean, they have a nice time, but they don't take them seriously. My students take the course very, very seriously, and the reason that's important is because I've done a lot of empirical studies that we're going to talk about today, trying to determine what makes a good negotiator. I love empirical work because I happen to have a degree in chemical engineering, so I'm used to working with math, and David Barnes, a very good friend who's a statistical expert and a law professor, Jake, as I know him. Jake and I have worked together many, many years, and he's helped me with the statistics. First thing I wanted to find out, are better students better negotiators? And when I first studied this, I hypothesized that better students would be. Why? Because we professors think they're more intelligent, more articulated, they're more articulate, they work harder, etc. No correlation. And I've done a second study, no correlation. Why? Because we're measuring abstract reasoning skill instead of interpersonal skill. So I've been working with Dr. Alison Abbey, a psychologist. We've been trying to find out, is there a correlation with emotional intelligence? Daniel Goleman says if it's not IQ, it must be EQ. It's neither. There's a very slight correlation with what's called effective communication, which means the ability to communicate feelings and understand feelings. Most of emotional intelligence is to understand your own feelings, to understand the feelings of other people, to communicate about those feelings. And we really thought, I shouldn't say it, Alison Abbey thought there would be no correlation because the statistics in the past have shown no correlation. I thought there might be one, but no correlation at all. Very, very slight in the effective communication. We haven't been able to publish it for 2 reasons. The psychology journals will not publish results that are not positive. They will not publish results that come out. They won't. They don't like results that show nothing. See, to me, they're statistically significant. I don't care if it shows a correlation or no correlation. No correlation is significant. So I would be happy to publish it. The other problem is she lost her teaching job because she had a non-tenure track position, and there are just so many jobs that have gone in the last few years. And so she had to take another job and has not been able to finish the whole study. But I mean, we had the results and we haven't been able to publish it. A few years ago in the Howard University Law Review, there was an article saying black athletes will not hire black agents. And the clear implication was if you're going to negotiate with the man, meaning the white owner, you had to have a white agent. Well, I thought, let's see if there's any correlation by race. So I did the study, and it was very hard to do the study because there's an old book written by Jeffrey Rubin and Bert Brown called The Social Psychology of Bargaining that must be now 40-some years old, 50 years old. There was a compendium of studies on different things affecting negotiating. Well, race is no longer something that anyone's allowed to study. It simply isn't acceptable. So there were almost no studies over the last 30 years on race. And so I had a hard time. I mean, I could look at things that said that blacks tend to speak more forcefully than whites, they make less eye contact. I mean, there's things like that you could talk about. But there wasn't much I could really talk about. But then I did the statistics, and what did I find? No correlation. And I wasn't surprised. That's what I expected to find. But Jake always says to me, what are you going to do if you find a correlation? I say, I'll publish it. I don't care which way it goes. That's why I do studies. If it shows a correlation, I publish it. If it shows no correlation, I don't publish it. Gender. Years ago, senior partners used to say to me, you think women can negotiate as well as men? And this was when women were first really getting into the legal profession and all the questions were coming from old males. And I will quickly say old white males in those days. And what worried me is they were making decisions whom to hire and whom to promote to partner. And if you're asking that type of question, you must have real doubts about the ability of a woman to negotiate. So I had a big database. I have probably the largest database of this kind in the country. It's been cited that way in books. I have several thousand students I've had over the years. And so I have a huge statistically significant database. And let's look at some of the differences. Men and women, when they talk, men speak more than women, except when they have an intimate relationship. Men talk about 60% of the time. Women only about 40% of the time. When it's intimate, it's reversed. And this is based on the work of Deborah Tannen, a university professor at Georgetown. She's done a series of books, You Just Don't Understand, Talking from 9 to 5, Gender and Discourse, That's Not What I Mean. She also has, I only say this because I love you, something that Mother loves. I haven't read the other one, Mother Loved Me, but You Better Than Me. I've met her, I don't know her personally, and she's a very, very interesting person. So when men and women interact and they don't have an intimate relationship, men talk more than women, and if women even approach 50% of the conversation, they're labeled as domineering. Men interrupt more often than women. Men interrupt to change the subject of the conversation. Women interrupt more to reinforce what was just said by the other person. Men are more direct. If man is hungry, he says, I'm hungry, let's get something to eat. Women are more likely to say, are you hungry? They're more indirect. And if you go past the next exit on the freeway after hearing that question, you're dead. I have been married for over 40 years, and my wife still says, would you like the salt? And I jokingly say, Deborah would like the salt. My wife's name is not Deborah, it's Katie, because we do both know Deborah Tannen, and she knows exactly what I mean. I get up and get the salt. So when she says, would you like the salt? She knows I don't use the salt. I know what that means. She would like the salt. Men overvalue their services, women undervalue their services. And there are a whole series of studies in 2 books I'll mention, both by Linda Babcock and Sarah Lassevier. The first one came out about 8 or 9 years ago, now 7 or 8 years ago, called Women Don't Ask. And what it was about is at the Carnegie Mellon Business School, where Linda teaches, 57% of the men who graduated negotiated their starting salaries, 7% of the women. And the difference in starting salary was $4,000. Linda has a huge institute now in negotiation, and several years ago she published a follow-up book called Ask For It, and that year 2% more women negotiated their starting salaries than men. When men and women negotiate for themselves, men outperform women. And that's true statistically, and she has a whole series of studies in both these books on that. Women undervalue their services. When men and women negotiate for third parties, however, the difference is gone. And in all the studies I've done 3 separate studies, I have never found a correlation by gender. The only statistically significant difference, interestingly enough, more women take my course pass-fail than men, which is consistent with the literature that says women are less comfortable with overt competition than men. And I don't know why. I have no sisters, my wife and I have no children. I don't know how it is we raise sons and daughters. Men have a BS gene. Peggy McIntosh of Wellesley College has published now a series of papers called Feeling Like a Fraud, where what she says is no matter how thoroughly unprepared men are, they think they can wing it and get away with it. No matter how thoroughly prepared women are, they feel unprepared. It's amazing. I can call on a man in my class and he can make a complete fool of himself because he's not well prepared and thinks he got away with it. I can call on a woman who performs perfectly and she'll come up and apologize afterwards. My wife has published 5 books. She's a librarian. She happens to have a PhD in library science, but she's a librarian at National Cathedral School in Washington. And one book was on history, and she won a National History Award from a group of professors of all things. And she was asked to go to this conference to talk about her book and get an award. Now, if you said you're going to give me an award, I would have thought this is wonderful. I can't wait to go and talk about my book. She hoped it would snow. It was in the Midwest in the winter. And I said, what are you worried about? She said, well, they're all history professors. I said, so what? The most they did was read the book. You wrote it. Trust me, you know it better than they do. Women are better listeners than men, and women are better readers of nonverbal communication. So what I've discovered, absolutely no statistically significant difference. The only thing I tell my women students when they have to negotiate salaries and that sort of thing is, I tell them you want to have an out-of-body experience. Since women don't feel as comfortable negotiating for themselves as men do, I say what I want you to do is take your resume and pretend you're negotiating on behalf of that person and it's not you. That's what I mean by an out-of-body experience. I really do mean that. If you were representing that person in negotiating the starting terms of employment, what would you seek for that person? And at first they laugh and then they realize, you know, that actually makes some sense. Now, let's talk about the impact of negotiator styles, and that's what the one book I co-authored with Jerry Williams is all about. Jerry Williams and Andrea Snyder have done 2 very significant studies on lawyer negotiating styles. In the 2 basic styles that you see, the cooperative problem-solving style epitomized by getting to yes, Fisher and Urey's book, you move psychologically toward the other side to try to maximize the joint return. You're open, you're trusting, you reason with the other side. This is what they call win-win negotiating. Both sides are going to do well. The competitive adversarial style moves psychologically against your opponent. You try to maximize your own side's return. You start with more extreme opening positions. You seek more extreme results favoring yourself. You're less open, you're less trusting, and you're more manipulative. Which style is more prevalent? Which style is more effective in terms of negotiating? They didn't ask lawyers to identify their own style. They asked lawyers to identify the style of other attorneys with whom they'd recently interacted, because we're prejudiced about our own style. They both found that about 2/3 of lawyers are considered cooperative problem solvers, and somewhere between 25% and 1/3 are considered competitive adversarial. 11% of the people in Jerry's study were not categorized. So about 2/3 of lawyers are cooperative problem solvers, and only about 1/3, or even less, are competitive adversarial. They then asked which of these people are effective negotiators, average negotiators, ineffective negotiators. 59% of the people who were cooperative in Jerry's study were considered effective, versus only 25% of competitive adversarials. 3% of the cooperative people were considered ineffective, 33% of the competitive people were considered ineffective. When Andrea replicated his study, the percentage of effective cooperatives fell slightly from 59% to 54%, and the percentage of ineffective cooperatives went up slightly from 3% to just under 4%. But the biggest change, the percentage of effective competitive adversarials, fell from 25% down to 9%, and the percentage of ineffective competitors went up from 33% to 53%. Why would 53% be considered ineffective? Because of what we teach children: you get more with honey than you do with vinegar. I actually have an article online with negotiatormagazine.com entitled "Everything You Need to Know to Be a Great Negotiator You Learned Before Kindergarten." And you know what's funny? It's true. Children learn to be intuitively manipulative negotiators. They're born with very basic needs, limited communication skills. They learn to make sounds, to be fed, to be put down for a nap, etc. When their skills improve, we teach them, you get a lot with consistency. They will go after one parent versus the other. They will ask over and over again. And they do learn you get more with honey than you do with vinegar, and they realize one thing that most adults don't appreciate: there's no such thing as bargaining power, there's only the perception of it. Parents think they have power, the children ignore it, and it's gone. 2 lawyers I know were negotiating one night in the kitchen. They both worked together as lawyers, spouses, and they were getting ready for a negotiation on behalf of a client the next day. The young Dory was out in the kitchen. They thought she wasn't paying any attention. And finally, one said to the other, "We have to ask for more than we hope to get." And this little voice said, "Daddy, is that like when I asked for 3 people to sleep over on Friday night when I really only want 2? Bingo. I said, talk to your daughter, she'll tell you how to negotiate. You then spend a fortune to educate your children, and they have to take a course like mine to learn what they learned before kindergarten. So when you see rudeness, what it really says is they don't know how to negotiate. Because the least effective way to get me to say yes to you is insult me. That's human nature. I don't care how much we try to pretend we're objective and non-emotional. We're human beings. If you insult me, I will look for a way to get even with you. And when we negotiate, that means screw you. On the other hand, if you treat me very, very well, I will feel guilty if I say no to you. And that can be a very significant factor. Now, when Jerry and Andrew did a study, and almost everybody talks about these 2 classifications, I finally convinced Jerry there's a 3rd category. Why? Because both in his study and in Andrea's study, they asked the most effective negotiators from both the competitive camp and the cooperative camp, what's critical to you? The number 1 goal for competitive adversarial people, they want to maximize their own side's return, the quintessential definition of competitive. The number 2 goal for the cooperative problem solvers who are considered effective, they want to maximize their own side's return, not the joint return, their own. Which says to us there are a number of wolves in sheep's clothing. A lot of people who are classified as cooperative problem solvers, we now call competitive problem solvers. And Ron Shapiro and Mark Jankowski, and Ron represented Cal Ripken throughout his career, and they both did a lot of sports, and they've run an institute in Baltimore. What's interesting in their book, they call this win-win negotiating, capital W, capital I, capital N on their side, small w, small I, small n on your side. And that's really what it's all about. This is the most effective way to negotiate. A recent study found that the best negotiators are considered by their opponents to be totally open and cooperative, but they admit to being not totally open and not entirely cooperative. But they do it so well, they're characterized as cooperative problem solvers when they're really competitive problem solvers. Another recent study showed that if you divide people up and say your goal is to maximize the joint return, and half of them are told you want to do nothing but make sure you do the joint return, and then you tell the others, but you also want to get more for yourselves than you give to the other side. The people who wanted more for themselves actually generated more efficient joint results than the people who were told simply to maximize the joint returns. Now in my class, I'll tell you why I found this to be true. My students want to get good results because it affects their grade. Now I will say I grade very, very liberally. I'm a very generous grader. We have a small class curve at George Washington and a large class curve, and I'm the only negotiation class over the small class curve. It has a cutoff of 35 people. All the adjuncts have a limit of 20 people. I'll take 50 or 60. I mean, I hate to kick people out. So the first year this happened, I went down to the dean to say, I would like permission to use the small class curve. He said, oh, we have no exceptions of any kind. I said, that's all right. You kick 30 people out, I won't have to worry about it. Let me know which 30 you decide to throw out of the class. He said, maybe we could negotiate. I now have permission to use the small class curve. And I do. I use the small class curve, and I tell the students that. Most of the students get A minus, B plus, some get A's, some get B's, but I mean, almost no one gets below B minus. So they really do have an incentive to take it. But they still want a good grade. Students are very grade conscious. We all were when we were students. I don't mean to say they're any different from us. But what they've learned is if you want to get a great deal for your side, you want to make sure you create the largest pie you can to divide, what economists call the surplus. I want to make sure we have a large surplus. Because the more we find to divide, the more I can claim for myself. I may want to get more of it than I give to you, but if we leave a couple of 100 points of bargaining results on the bargaining floor, we both lose. And my students, by the end of the semester, learn to be incredibly efficient. It's amazing. They rarely leave points on the bargaining table. And they're not allowed to discuss the points. I mean, that's one of the rules of the course. That's a violation of the class rules. They may not discuss how many points each item is worth. They can say, I want this more than that. They can say this is twice as valuable, but they can't say this is worth 100 points and that's worth 50 points. That they can't do. And they generate very, very efficient agreements. And the first thing I do at the end of every agreement, I talk about how efficient they were. I talk about what they should have agreed to maximize the joint return. And what that means is the items you value a lot more than I do, I should give to you in exchange for the items that I value more than you do. Now, most lawyers don't think of negotiations as structured. They negotiate day after day after day, and they almost never think about what it is they're doing. I mean, literally, they never think about it. When I was in practice at Morrison Forrester years ago in San Francisco, I actually did because I had taken a course in law school with Jim White at Michigan, who was one of the forerunners in clinical negotiating. He and Neil Peck out at the University of Washington were the first two professors to really do much in the area of clinical negotiating. And Jim graded the course the same way. And we took it seriously. And I got into practice, and I really thought a lot about negotiating. I also had a master's degree in labor arbitration, collective bargaining. And so I had studied also in graduate school. Really, the book that was one of the best books ever written by Walton and McCursey called The Behavioral Theory of Labor Negotiations, a very erudite version, really, of getting to yes, written in 1965. And it was a very academic book on how you want to make sure the union gets what it wants. It doesn't affect the employer negatively. The employer gets what it wants, that the union is willing to give it. And then they're going to fight over the items that involve money. And I laugh. I mean, when Cal talked about what's going up in Wisconsin, what's going on here in Ohio, my advice to the governor is go to the damn bargaining table and negotiate. And I mean that seriously. Go to the table and bargain. In Wisconsin, the union gave over $100 million in reductions. They agreed to contribute more to their health care, to their pension. And what did he do? He took the $100 million that they gave him, he gave a $100 million tax cut to the rich. I'm serious. He gave $100 million in tax cut. That's how he wanted to balance the budget. Take it away from the union, give it to the rich, and say, oh, we have a shortfall. Why didn't he put the $110 million in give-backs to the budget? And the same thing in Ohio. The reason the public sector unions have done so well, and I would say they've abused their power, I don't mean that at all shamelessly. I come from California where they really abuse their power and they have tremendous benefits, and poor Jerry Brown's having to deal with what Schwarzenegger was unable to deal with. The fact of the matter is politicians are gutless and they take bribes. And they're not at all governed by profit motive. They always put off things in the future. So CalPERS, which is the Cal Public Employees Retirement Plan, it's going broke. The university system's going broke. I taught at Davis for 5 years, and what they do, they bought out all of my colleagues once they got in their 50s by giving them all sorts of fictional years of retirement to get rid of them. So they'd all retire when they could have taught another 10 or 15 years. So that's what they did. They should have bargained. So here are the 6 stages that we'll talk about. The preparation stage, where you really want to do all of your homework, know what your opening position will be, what your goals are going to be, what your bottom line, we'll come back to some of this. The preliminary stage, where you establish a relationship with the lawyer on the other side and a good negotiating environment. The information stage, which is value creation, you're trying to find out what's on the table to be divided between the parties involved. The distributive stage, which is value claiming, you're claiming the surplus you've created during the information stage. And I just published an article called The Inherent Tension Between Value Creation and Value Claiming, because I have to be fairly open during the information stage, although not entirely for reasons we'll talk about. And then we get to the distributive stage, and we're going to claim the value. And I don't want you to know how much you're giving me. I want you to think I'm getting no more than what I'm giving to you, even if I'm in fact getting more than I'm giving to you. The closing stage, where you solidify the deal near the end, and the cooperative stage, where you want to make sure you maximize the joint agreement. Now, thorough preparation really is critical, and my students learn that in a hurry. And when I was in practice, I spent a long time on the facts, the law, the economic issues, whatever they are, because I don't like to be surprised by the other side. So I want to know what's relevant to this interaction, and I want the good and the bad. I want to know if we have weaknesses. I want to know if we have strengths. If we have a weak case, I'm going to tell the client, we have a weak case. Let's try and settle it. If we have a strong case, you might well be willing to litigate. We'll certainly go for a motion for summary judgment. But I want to know what our situation is. How good is it? And then you want to ask the 3 questions that are critical here. What's your bottom line? How high or low are you going to go? What Fisher and Uriel like to call your BATNA, your best alternative to a negotiated agreement. I simply call it my bottom line. How high or low will I go before I go to trial? I do business with somebody else. I do whatever my non-settlement alternatives are. The second part of that question is equally critical. What happens to my opponent if they don't reach a deal with me? And most lawyers never look across the table, and I'll give you a perfect example. Years ago, a very good friend of mine representing a big corporation called me up. He was beside himself. He was involved in a very difficult negotiation, and he laid it all out. When he got done, I said, what happens to your company if you don't settle? He said, we're bankrupt. I said, how bad is that? He said, what do you mean, how bad is that? We're bankrupt. I said, could you reorganize? He thought about it and said, yes. I said, what happens to the other company if they don't reach an agreement with you? He said, I have no idea. I said, think about it. He said, they're bankrupt. Could they reorganize? No, we're their main client. Without us, they're out of business. He had the bargaining power. Once he looked across the table and realized the other company had to reach an agreement with his corporation, he got a good deal for his company. They had to reach a deal. He didn't. That's bargaining power. How much do you have to reach a deal compared to how much I have to reach a deal? If I have greater needs than you do, you have bargaining power. If you have greater needs than I do, I have the bargaining power, assuming I know how to use it. And so you want to determine your own bottom line, and you want to put yourself in the shoes of the other side. You want to establish realistic but elevated aspirations. There is a direct correlation between aspirations and outcome. People want better deals, get better deals. I do this with my students every year. I give them some early exercises for practice where I ask them, how much do you hope to get? How little do you hope to pay? The people who expect to get a lot, get a lot. The people who don't expect very much, don't get very much. The people who expect to pay a lot, pay a lot. The people who don't expect to pay a lot, don't pay a lot. It's amazing. As trite as it is to say that, it's amazing. Some people are so happy when they get everything they want, and I always say one of the greatest myths of negotiation is, I must be a great negotiator. I always get what I want when I negotiate. There's only one way you can always get what you want when you negotiate. Don't want anything. Simple as that. And you'll be very happy until you take a course like mine. Then you'll find out you're not doing so well. And I'm not joking. That's the one good thing about the course. They really find out how they're doing compared to others on the same exercises. It's also the bad part of the course. It's hard for their egos. I have students in my office occasionally in tears. They're having trouble coming to the grips with the fact they're having trouble. Now, I'm glad they come in because I start working with them. That's why I give them a series of practice exercises so they can experiment. We'll start talking about what it is that causes them to be not doing so well. And the biggest thing is they normally aren't reaching very high, and they're scared to death of a non-settlement. And I say, don't be afraid of a non-settlement. I mean, normally you don't do so well if you have a non-settlement, but I say, do you think the other side wants one? This past semester, I had about 54 people in my class, and most of them were one-on-one, so that's 27 negotiations per week. They did, I think, 12 exercises. And I think of all those negotiations, I had 1 or 2 non-settlements the entire semester. That's it. They almost never non-settle. So I tell them, for God's sakes, be willing to walk away and let the other side sweat. So establish realistic aspirations and don't make them so far away that you don't have any hope of getting them. Because if you do, you'll either end up with an impasse or you'll fall to your bottom line. So you have to establish goals that are at least attainable. And that's one of the hardest things to think about. What's your opening offer going to be? Some people say put a very reasonable offer on the table. The other side will respond in kind and have a very pleasant interaction. A wonderful theory, but false empirically because of a phenomenon called anchoring. When I start by giving you a very nice opening offer, you actually move away from me psychologically. You begin to think, I'm going to do much better than I ever anticipated, and you try to take advantage of that opportunity. You're much better off starting with a lower offer or a higher demand, because now you begin to undermine my confidence, and I start moving in your direction. And this really has been proven. I give my students a one-page description of a tort action where I say, you're the defense lawyer, and I want you to answer 2 questions. What's your opening offer going to be? How much do you think you're going to have to pay to settle this lawsuit? Every single student gets the identical information with one slight twist. Half of them are told the plaintiff has just demanded $100,000. Half are told the plaintiff has just demanded $50,000. The people facing a $100,000 demand planned a higher opening offer and expect to pay more than the people facing a $50,000 demand. Nothing else has changed. Chris Guthrie is now the dean at Vanderbilt Law School, published an article a few years ago where he did this with magistrate judges who often mediate in federal cases, where they are quite good at giving you their advice where you should come out. Judicial magistrates tend to be much more direct than those of us who are private mediators. And he asked them to value big federal cases. And the only thing he varied was how much the plaintiff was demanding. The higher the demand, the higher the value of the case. Simple as that. The impact of anchoring. So when in doubt, start higher. Gain-loss framing. If I offer you a sure gain and the possibility a greater gain or no gain, you tend to be risk averse and take the sure gain. If I offer you a sure loss and the possibility of a greater loss or no loss, you tend to be a risk taker. Let's do a quick study. At the end of the presentation, you've got that door. Calvin will hand you a $100 bill. If you got that door, you get a sealed envelope, 4 out of 5, which will be empty. 1 out of 5 will contain $500. How many go out this door and get your $100 bill? Don't be shy, folks. How many hope it's your lucky day you'll be the 1 in 5? All right, get the names of those people and don't trust them. Let's change it slightly. If you go out that door, you have to pay Calvin $100. If you go out that door, 4 out of 5 don't have to pay anything. 1 out of 5 has to pay $500. How many go out that door with your credit card in your hand? How many go out that door? Res ipsa loquitur applause. And it really does. Sure gain, most people take the sure gain. And they did a study, I want to say it was Ted Eisenberg, because he does a lot of statistics. It was someone at Cornell, and I think he was one of the co-authors. And what was interesting, there were actual cases that went to trial where they got the final offers of the plaintiff and the defendant. What they were trying to determine is who is more likely to either overestimate the likely outcome or underestimate the likely outcome. And what they discovered is defendants were 5 times more likely, I should say, they underestimated the likely outcome by 5 times more than the plaintiffs overestimated the likely outcome. 5 times. Why? Probably gain-loss framing. The plaintiffs and the plaintiffs' lawyers are both facing a sure gain, usually because it's a contingent fee basis in so many cases. So they're not likely to go to trial if they think the offer is good. But the defendants are looking at a sure loss, so they're more likely to go to trial. And the average result was the plaintiffs overestimated by about $50,000 in each case, and the defendants underestimated by about $250,000. It was an amazing difference. Confidence is a critical factor. Years ago, I had a wonderful student, and I would share his name, but he has asked for anonymity, so I've cited him anonymously in my book. He's a senior partner in a firm on the West Coast, and he doesn't want people to know how devious he is. I don't think this is devious. It's brilliant, but he didn't want people to know how brilliant he is. He wrote a paper where he said whenever he got an exercise, he tried to determine the most he thought he could possibly get for his side, and then he added something. It seemed unreasonable. He worked on all of the arguments supporting that seemingly unreasonable position until he felt comfortable, and then he walked in and negotiated with his opponents. Week after week, he cleaned them out. It was amazing. And at the end of the term, I always talk about the most successful negotiators, and I asked the members of the class, what'd they do so well? Several people said to him, he wasn't really that good a negotiator. It's just that when he got down to the end, he seemed so sure he was right, we thought we were wrong. And I said, in one sentence, you define the art of negotiating. He developed such confidence in his position that they thought he was wrong. The only time he didn't get the best settlement, or about the best settlement in the class, was a very strange one. He had to negotiate against, I think it was his roommate and a very close friend. Now, I have an exception for people who are spouses or putative spouses where I will make sure they don't oppose one another in my class, because I say those relationships are more significant than this stupid course. But if you're just friends, you don't get excused. So they'd known each other for the years. They went up to negotiate. We had an in-class exercise where I said, you have to have the results done by like 4 o'clock, and if it's late, it's a non-settlement. So they went off to negotiate. 4 o'clock came, everyone else came back in the room with their agreements, nothing from them. About 5 after 4, he comes running in with what was the best settlement in the class for his side. And I said, you can keep it, it's a non-settlement. And he was so upset. I mean, he really wanted to tell me off. He didn't. He was very professional. But what he didn't realize is I had nothing to do with it. I know it happened. His roommate knew he couldn't beat him. He waited till after 4 o'clock and caved in. I would say no. I know exactly what happened. I never said that to him because I didn't want him to realize how devious his roommate was. Now, in the preliminary stage, you really do want to establish rapport in a positive mood. When I get in, and in this country we're a very casual culture, I want to get on a first name basis. I want to personalize the interaction. Not in a negative way, in a positive way. I want it to be Charlie and Mary, not Miss So-and-so and Mr. Craver. I don't want you to think of me as Mr. Craver from this big law firm and this client. I want you to think the two of us are negotiating. And it's harder to be nasty to someone you think of as a real person. It really is. So when we get on a first name basis, we might talk about where we went to law school or whether we like certain music or what about the weather. I mean, something that's not terribly controversial. We'll get to know each other a little bit. And that's what this is all about. And we want to establish a positive negotiating environment. What studies show statistically is when people begin a negotiation in a positive mood, they behave more cooperatively, they reach more agreements, and they reach more efficient agreements. When they begin in a negative mood, they reach fewer agreements, they behave more adversarially, and they reach less efficient agreements. So I want to establish a positive mood. And when you encounter someone who's difficult, there are 2 books by Bill Urey I'll recommend. The old book from the mid-1990s is called Getting Past No. The subtext was dealing with difficult people. And his more recent book that came out now about 2 years ago called The Power of a Positive No. How to say no to somebody and keep the process going favorably. And they're both very, very good books. He's a wonderful writer. He's written so many very, very good things. Good negotiators are very, very good communicators, verbally and non-verbally. They're good readers, they're good listeners, active listeners. They hear more than most of us do. They hear verbal leaks. And where I say I can't go higher as opposed to I don't want to go higher. When I say I don't want to go higher, you know I will. That's what we call a verbal leak. I'm not inclined to go higher, another verbal leak. You want to listen carefully for words that undermine what I seem to be saying. This is my final offer. I don't have much more room. That means I have. So you want to listen very, very carefully. You want to ask a lot of questions. We'll talk about that in the information stage. But what questions are you going to ask? And a recent study showed that the most effective negotiators ask twice as many questions as their less effective cohorts. Twice as many. And at the beginning, you want to ask broad, open-ended questions. Get me talking, because you're going to get a lot of new information. One mistake we often make when we negotiate, we're intimately familiar with our side, and we think the other side knows what we know. They don't, of course. So when you get me talking, I often give you a piece of information I assume you know, but you don't. So you want to listen very carefully, and you want to look for nonverbal signals. And some of my students are very, very good when it comes to these skills. They really are. It's amazing. Others do all the talking, and they get nothing. They give all the information away, they make concessions, and in the end, they normally don't do very well. Good negotiators are patient and persistent. One thing I do, I mediate particularly employment discrimination cases because it's one of my areas of specialization. And the biggest thing I've learned, I learn more about negotiating when I mediate than when I negotiate. I sort of laugh when I say it because when people say, what do you do when you mediate? I negotiate. What I do as a mediator, of course, I negotiate. But what gives me bargaining power is the fact that I'm not interested in the dispute, and strangely enough, the fact I have no power. That's what gives me power. I've had parties say to me, I don't want you to tell me what to do. And I always say, not only will I not tell you what to do, I can't tell you what to do. In fact, the first thing I say when I'm going over the rules of mediation is, I have no power to tell either side what to do. That's what gives me power. They listen. I assume I have power, and they give it to me. And I don't mean to tell, I never tell them what to do. I do a lot by asking questions. And what I try to do is I try to get the plaintiff to think they could lose. What's the chance you could lose? Then I try to get the defendant to think, what's the chance they could win? The other side. And how much might you lose if they win? So I'm trying to get the plaintiff to focus on their downside risk. I try to get the defendant to focus on their upside risk. Sometimes I do it right in the same room where they're together. Sometimes I do it in separate caucus sessions. But what I've learned over the years, and Jerry Williams has really convinced me of this because he's a real believer in it, it really takes time for people to decide to lower their sights. It really does. Don't rush the process. And that I really have learned tremendously over the last 10 years. I had a case several years ago where the first day I thought I knew where they would settle. I asked them questions to see if either side would move in that direction. They made it absolutely clear that was not acceptable. They asked if we could have a continuance. We kept going. 8 months later, 8 months, and I was about to say no more continuances. They ended up exactly where I thought they would the first day. Exactly. Why did it take 8 months? Because they weren't willing to give up until then. A lot of times they want to look backwards. They want recriminations. And I always give them a lecture how if you want to move forward and you want this to be a forward-looking process, try to mediate and try to settle. If you want to look back and spend your time deciding who's right and wrong, then you want to go to court. But you're not going to enjoy the process. It's not going to be fun for anybody but the lawyers. And I mean, I had a couple of clients at the end of a trial tell me, if I had known what hell this was going to be, I would have settled. They both won. I enjoyed it, but they didn't. The only people who tend to have fun in the courtroom are the lawyers. We do. We tend to have a lot of fun in the courtroom. So give people the time they need to lower their sights. And if you rush it, they won't. It's amazing. That's one reason a lot of judicial mediators have trouble. They want so badly to tell us to settle. I mean, I teach at judicial conferences, and they often say to me, you know, I'm not a good mediator because I'm just so used to telling the parties what to do. I try never to tell them what to do. I may push them, but I try to do it more with questions. What Len Riskin, who writes a lot on the mediator style, calls the elicitive style, or the old term was the facilitative style. Elicitive meaning you ask a lot of questions, as opposed to what they call either directive or evaluative. On the other hand, every mediator I know, we do evaluate. I'm often asked my opinion. Now, I'm very careful when I give it because I have no idea what a jury is going to do. But I mean, I've said to someone, you're not going to succeed in a motion for summary judgment. We have a clear litigable issue of fact here. It's going to go to a jury. Other times, I may say to the plaintiff, you're going to have a hard time getting past a motion for summary judgment. You don't have much evidence. So I will give my opinion somewhat that way, but normally if they don't ask for it, I don't. It's their case. My wife often says, do you care when they come out? No, I have no interest where they come out at all. I hope they reach an agreement. It's their dispute. And some of them are fascinating. In sex harassment cases, I'm amazed how often all the claimant wants is an apology from her employer, not the harasser, saying, I'm sorry I didn't move more swiftly to correct this, and two, a statement that she's a valued worker because she thinks the reason the employer didn't move more quickly is because the employer doesn't value her. I had a woman with a PhD who was a department head years ago, head of a big department for the employer, and I met with the head of the company, and I said, how good is she? She's the best I have. Can I tell her that? No. I was shocked. I said, why not? She won't work as hard for me. This is theory X and theory Y. And I said, she'll work even harder. Nope. He gave me a half-baked statement. She's a valued worker, but not a great worker. I asked me to apologize. I never apologize. I got a half-baked apology. And I can't convey more in the other room. That's unethical. All I convey is what the party in the caucus session told me to convey. I went in the other room. I said, you're a valued worker. The employer gave a half-baked apology, and she dropped the entire lawsuit. I'll never forget. I looked at her and I said, you're still not satisfied, are you? She said, no, I'm quitting on Monday. I'll never forget it. I'm quitting on Monday because he doesn't value my services. I had another dispute, again, a department head and a corporate owner, the company owner. And I talked to the company owner. He said, I will not talk to so-and-so until he apologizes. He was so rude in our last discussion, I won't even talk to him. Good worker, he's the best I have. Can I tell him that? Yes. I talked to the department head. You like working there? Yes, but I won't talk to the owner until he apologizes. He was rude to me. Can I tell him you like working there? Yes. We got to the joint session and I said, you're the best department head of this company and you love working here, and that was the end of the dispute. And to this day, I have no idea what the dispute was about. I don't even remember. It was done in 10 minutes. It was totally an emotional dispute. He felt as if he wasn't respected, and the owner somehow felt he didn't respect working there. And once that was on the table, that was the end of the dispute. I have no idea what their dispute was about. I mean, they talked about it a little bit, but very vaguely. And to this day, I don't know what it was about. It was done. It's amazing how powerful an apology can be in a negotiation, because so often the underlying issues are emotional. Sometimes you have to say, I'm sorry, I did something wrong. That's critical. There are times when I have to admit I've done something wrong. But other times I can say, I'm sorry this has happened to you. I'm not saying I'm liable. I'm sorry it happened to you. Let's see if we can rectify it. I'm sorry you feel the way you do. I'm acknowledging your feelings. It's amazing how powerful that can be. The University of Michigan Hospital, a number of other hospitals have discovered when they make a mistake medically, what they should say to the patient is, I'm sorry, we made a mistake, we're going to correct it. And lo and behold, they've cut the number of malpractice cases way down. Why? Because the patient doesn't want a lawsuit, the patient wants to be healed. And they want to hear someone say, I'm sorry. It's amazing the power of an apology. The cooperative stage, you want to make sure you maximize the joint return. During the prior discussions, we have over and understated the value of items for strategic purposes. If I think you really value something I don't particularly want, I will tell you we want it, because I want you to think when I give it to you, it's a major concession. If there's something we want a lot and I know you don't value it, I will simply say we would like to get it, because I don't want you to realize the size of the concession you've made to me. Now, people will say, well, isn't this unethical? Let me just mention Model Rule 4.1. A lawyer may not lie. Thou shalt not knowingly misrepresent material law or material fact. When is a lie not a lie? When it's by a lawyer. If you read comment 2 says in the negotiating context, there are different expectations. Certain statements are not considered statements of material fact. When you talk about your settlement intentions, i.e. how high or low you're willing to go, non-material information. When you talk about how you value the items being exchanged, non-material information. So I can puff and embellish, to use the terms my professional responsibility colleagues like to use. I prefer to say I can lie through my teeth as long as it goes to my settlement intentions and my values. I cannot misrepresent anything else at all, and if you even think about it, you're crazy. I often tell my students, I have never participated in a legal negotiation where both sides didn't lie. Never, as an advocate or as a mediator. They always lie to me. But I've almost never encountered a lawyer I thought was dishonest. Why? They never lie about what I have the right to know. They don't lie about the facts. They don't lie about the law. They don't lie about the economics. They tell the truth. They may not tell me, but they don't lie. I have rarely encountered a lawyer I thought was dishonest. If I did, I would never trust that person again, and I would tell everybody in my firm, don't you ever trust so-and-so, they're a liar. You'd be dead. In my class, every now and then a student is accused of an ethical violation. I actually have the rules in force. There would be a formal trial if they wanted to seek a sanction, but they normally don't. I've never had a trial in all the years I've taught my class. What they do is they informally say, so-and-so did this, and I'd like to know whether you think it was appropriate or inappropriate. Almost always the class says it's puffing, don't worry about it. Every now and then the class says, that wasn't puffing, that was inappropriate. That student's dead. They're going to have a non-settlement because their future opponents don't trust them. Integrity is critical when we negotiate. So in the cooperative stage, we have under and overstated the value of items ethically, but now we've reached an agreement, we've initialed everything. This is where we want to make sure we maximize the joint return. I'm going to offer to trade items that I think may have ended up on the wrong side of the table, to see if we can expand the pie and simultaneously improve our respective positions. I hate leaving client satisfaction on the bargaining table at the end of a negotiation. That is a terrible waste, and so I want to maximize the joint return. And this is why your reputation for integrity is critical. Think of how much you do figuratively or literally with a handshake. When I negotiated in practice, and even now, because I work with lawyers occasionally and I mediate regularly, even though they puff and embellish, I have almost never encountered a lawyer I thought has misrepresented the material information. Separate caucus session, and often they'll tell me things that they won't let me tell to the other side, which of course in a separate caucus session, everything's confidential except what they authorize me to disclose. And I mean, someone will say, go in the other room and demand $5 million, but I'm really willing to come down the $1.5 million range, which helps me immeasurably. I'll go in the other room and say they want $5 million. And the other side will say, well, I'm willing to offer them $500,000, but I'm willing to go up to $750,000. Now I know we're only $250,000, $400,000, whatever it is apart. I had one case where the parties started $25 million apart. It was a big federal case. And by the time we got done, they settled. That one took about 10 months. They settled. So you can't puff and embellish, but you cannot lie, because if you get caught, you are dead. I can even put you on the net, and if you think that these things go away, when you're free, just go home and type in poop girl. I'm not joking, poop girl, you heard me right. My colleague Dan Soloff has several books on the internet and privacy. She is an Asian girl who had a dog on a public transport. The dog pooped. She did not pick up the poop. The picture was taken. She's even in Wikipedia. That was probably 15 years ago, and I'm not, just type in poop girl and you'll understand what I'm talking about. Up it will come. Last thing I want to talk about is how critical it is to maintain your negotiating skills. Most people in this room have not had a full semester course in negotiation in law school. More and more do, but even at my school, we have a number of separate sections. Still, many of our students graduate with no training because we have 540 students in each class. And we just don't have that many negotiation courses. We do. We have 2,000 students at the law school, counting our LLMs. We have one of the biggest law schools in the country. I think we're the third largest law school in the country. Georgetown, Harvard, and GW are the three largest law schools in the country. And it really is amazing. They graduate with minimal training in negotiation. And that's what they do every single day. And when you're in practice, if you try a case, at the end of the case, what do? You sit down and do a post-mortem. How did I present the case? Did I have a good theory? Did I present the witnesses well? Did I ask the right questions? We really try to figure out what we could have done differently. When was the last time you sat down at the end of a negotiation and thought, how did you do? Now, I think you have in front of you, or in those materials, if not, I have a thing here. I don't have, oh, it is. They printed this today, and I don't know if they have extra copies here. It's called Beyond the Bar. It's a toolkit for the Beyond the Bar program. I know they have some, and you can ask for them. They had some this morning for the students. This is a summary of everything we've talked about, and it's simply called the Toolkit for Effective Legal Negotiation, because I teach Beyond the Bar programs for West. And the last page is a post-negotiation assessment, where you really want to ask, how did you do? And at the end of the negotiation, the two most basic questions: what did you do that you wish you had not done, meaning you made a mistake and you want to make sure you don't do that in the future. And we always make mistakes because no matter how thoroughly prepared we are, it's an extemporaneous exchange. They're going to do something I didn't anticipate, I react to it, and I think later, oh, I shouldn't have done that. I should have done something different. But the more significant question is, what did you not do that you wish you had done? The first question, you eliminate something you shouldn't have done. But the second question is really designed to think about what you will do differently in the future. And there are studies that show the best way to improve your negotiation skills, not every time, because you literally negotiate the whole day. I'm not joking when I say that. After your more significant negotiation, ask yourselves, how did you do and what you would have done differently in the future? And it's amazing how much you'll learn. Every now and then pick up a book on negotiating, just go into Amazon, type in negotiation. They're publishing books almost every month. And I mean, I get paid to read and write, as Calvin was talking about. I have 4 books on negotiating. I mean, I get paid to read and write because I often jokingly say I have this very hectic schedule. I work 5 hours a week, 26 weeks out of the year, and I don't know how I'm able to maintain this schedule. Right now I'm finishing 3 book revisions, and we're almost done, thank God. But I mean, I'm only teaching 1 course this semester. I mean, I have an easy semester. You have clients, you have billable hours, you can't read what I get paid to read. But every now and then, pick up a good book on negotiation. Several that have come out in the last couple of years by people at Harvard Business School. Lax and Sebenius' book called 3D Negotiation. Jim Sebenius teaches at the business school, and they have a big negotiating consulting firm they run together. And the other is Deepak Malhotra and Max Bazerman, also the Harvard Business School, called Negotiation Genius. Two very, very good books. The business schools are much more advanced than the law schools are in this regard. Now, the one last thing I will say here about ethics is something that I don't have on the machine, and that has to do with electronic metadata. When you create a Word or WordPerfect file, every single keystroke you make in that file is recorded electronically. Every single keystroke, every change, addition, deletion, everything. And when you send that file to me, you think I'm going to look at what you have on the screen. I can set my software so I can see every single change you have made in that file. It's called mining the metadata. I can set my software so that I will call up the metadata, and you may have written a demand letter where you initially demanded $750,000, then you decide to make it $850 or $675. I can see the change you've made. You made one significant legal argument, you decide to delete that and replace it with another one. I can figure out why you deleted the first one. That gives me tremendous knowledge. Now, the ABA says you can mine the metadata because everybody knows it's there, and most people, particularly with gray hair, look at me as if, what the hell is he talking about? They don't know it's there. It is there. I think the ABA is wrong. A number of states have agreed with the ABA. New York, Maine, Alabama, and a couple of other states have disagreed with the ABA, and I happen to admit I share their view. If you knew the metadata were there, you wouldn't send it to me. But they all agree on one thing. Under Rule 1.6, governing client confidentiality, you have a duty not to include the electronic metadata in the file you send to the opposing lawyer. How do you do it? 3 simple ways. Talk to your computer people and get scrubbing software. Scrub the Word file or the WordPerfect file before you send it. So scrub the file. It simply eliminates the electronic metadata. It's simply called scrubbing software. Number 2, create a brand new file. Give it a new name and insert the old file into the new file. So insert the old file into a brand new file. That too eliminates the electronic metadata. The third thing you can do is publish a PDF and send me a PDF file. That eliminates the metadata. But don't send me the file. I know a couple of lawyers that I've been in their office, they say, let's see what the file says. And it comes right on the screen, every single word you've put in that file from the minute you create it. Now, I have checked, if you simply send email, it doesn't contain electronic metadata. I checked with someone this week to make sure that was still true. So if you send me an email message, I can't see the changes you made in it. It's only when you create a Word or WordPerfect file or something similar to that. Any questions that anyone might have? Yes?
Hi, thanks again for coming.
No, thank you.
With the information stage, I was just wondering if you have any suggestions on techniques if both sides realize that they want to get the other side talking. I mean,
they're both going to ask a lot of questions. They are, and basically, you can't refuse to give me information because then we're going to have no negotiation. Mm-hmm. Now, we're both going to be coy, particularly at the beginning, and we'll talk about, I didn't talk here, blocking techniques where you avoid answering the whole question, you answer part of the question, you misinterpret the question, that sort of thing. But the fact of the matter is, if we want to have an efficient negotiation, you still have to tell me what the items on the table are. Mm-hmm. So I still have to be willing to tell you, maybe not at the beginning as we go through the negotiation, I have to tell you the items I value. Now, I may over-understate the value for strategic purposes, but if I don't put the value of if I don't put the items on the table, we won't know how to negotiate. We may have 50 things to negotiate. I've been in collective bargaining where you're negotiating a 400 or 500 page document. I mean, not every term, although if it's a new agreement, a new relationship, you may be negotiating a huge number of terms. But what happens there is, when I ask you questions, you're going to slowly tell me what it is you want, and I'm going to have to give you some of the same information. At the beginning, we're both going to be very, very coy, unless if we really know each other and we're normally quite open, we'll be quite open. I mean, I'll give you a perfect example about 4 or 5 years ago, the huge strike and lockout in the West Coast grocery industry went on for a long time, and they lost several billions of dollars because of that. And the biggest issue was healthcare. Healthcare is a huge issue with collective bargaining right now. They came to the East, and the 2 main lawyers involved, it was again a multi-party negotiation, knew each other well, and the union said, we can't agree to pay premiums. That's not acceptable to the members. And one thing I always tell my labor law students, please remember union officials are political. They have to get reelected, just like politicians. So listen to them. So what they say, how can we lower the cost? Raise the deductibles, raise the copay, we'll agree to that in a minute. And they did, and they cut the cost. And the fact of the matter is, and as the union people said, when someone has to pay $100 or $150 a month premium, they get damn angry. When they get sick and they have to pay a high deductible and a high copay, they're so glad they have health coverage, they don't complain. And it's true, and that's really politically what they have to do. And that was a perfect example of getting to yes, solve the problem. So figure out what the underlying issue is, and there it was cost, medical cost. How can we reduce the cost in a way that's politically acceptable? And another thing on politics, the NUMMI Corporation out in Fremont, California, that was formed originally with Toyota, General Motors. And what happened is General Motors pulled out a couple of years ago when they had to get the federal bailout, so Toyota was left in, the UAW was there. UAW had granted about 22 to 25% wage cuts to General Motors and Chrysler. And Toyota went in and said, we need wage cuts at NUMMI. And the UAW pounded its chest and said, we can't do that, and Toyota closed the plant like that. They let off 2,500 union workers and about another 2,000 non-union workers. They closed the plant. What the UAW didn't understand is that's not how the Japanese negotiate. You don't pound your chest and play that game because it's a loss of face. And what the Japanese didn't appreciate is the UAW had to put on a show for the members before they cut the wages.
Thank you.
Yep. Any other questions? I do want to thank Cal for asking me here. It is an unbelievable privilege to be in this position because I look at the people who have been here before, and you have had literally a virtual who's who of people. I mean, I think of Bob Manukin and Carrie Mengel-Meadow and Shell from Penn, and who else I have in there, and I'm leaving out Russ Kropkin from UCLA, some just unbelievably top people in the field. And it's been an absolute privilege to be here, and I thank you very, very much for your Thank you very much. Thank you so much, and thank you so much, Cal, for having me.